NASA case confirms that Regulation 69 is a procedural expression of Section 44A's constitutional complementary mechanism. In Raila 2017, the petitioners challenged the integrity of the election on the basis of failures in electronic transmission, verification, and accountability. Although the Supreme Court did not nullify the election specifically on voter identification grounds, the decision fundamentally altered Kenya's electoral jurisprudence by emphasizing that elections must be transparent, traceable, auditable, accountable, and independently verifiable. The court repeatedly stressed that constitutional compliance depends not merely on whether votes are cast, but whether the process through which they are cast, identified, recorded, and transmitted can later be verified through documentary and technological audit trails. The principle later became central to both the Regulation 69 identification cases and Regulation 72 assisted voter cases. Then I refer to the Maina Kiai case, and I'll skip directly to, because it's taking us long to get there, I skip directly to UDA, the UDA case. On the eve of the 2022 general election, let me just mention, the Maina Kiai case, Kenya Human Rights Commission versus IEBC. It is important. In that case, the petitioners challenged IEBC for issuing a directive proposing to abandon the printed register entirely and rely exclusively on KIMS-based identification. The High Court, building on the NASA case and the constitutional principles articulated in Raila 2017, quashed the directive and held that the printed register was not merely administrative, but a constitutional safeguard. The court found that abandoning the manual register violated Articles 38 and 86 of the Constitution. However, on the eve of the election, 2022 election, the Court of Appeal intervened through the case of UDA versus Kenya Human Rights Commission and others. It stayed the High Court's directive requiring immediate universal deployment of the manual register. It did so without rejecting the legitimacy of the complementary mechanism. Instead, the Court of Appeal held that the following sequence governed voter identification. First, biometric identification through KIMS. Second, alphanumeric search where biometric verification fails. And finally, resort to the printed register only after confirmation of KIMS failure beyond repair or replacement and with the Commission's authorization. The court therefore accepted the constitutional necessity of the manual register while insisting that its use remain controlled and sequential. The Supreme Court applied this hierarchy directly in Raila Odinga 2022, where the petitioners alleged widespread KIMS failures and argued that the resulting identification process was unverifiable. The Supreme Court upheld the election, finding that although KIMS kits failed in 235 polling stations affecting approximately 86,889 voters, the IEBC had properly implemented the fallback mechanism through Form 32A documentation and manual identification procedures. It concluded that the integrity and verifiability of the identification process had been preserved, notwithstanding the technological failures. So Raila 22 confirms that technological failure is not fatal in itself, and that matters constitutionally. What matters constitutionally is whether the fallback process remains documented, traceable, and verifiable. In that case, the election survived because the fallback process was properly documented through Form 32A. I've cited a couple of cases on scrutiny from the High Court, which I will not point out, which I'll not read out. But let's go to the evidence now. The evidence in the present case comprised largely of assertions that the petitioner's agents had not seen the physical register at the polling stations. PW1 stated that there was no manual register at the polling stations. PW2, the petitioner's chief agent, gave contradictory evidence on this issue, stating that he did not see a manual register in any polling station that he went to, and no agent told him that they saw a manual register. That the agent at Gitiburi polling station told him that some people were voting even though they were not identified by KIMS. In cross-examination by Mr. Mongela, however, he stated that he did not witness any KIMS kit malfunction, and the agents did not tell him how KIMS kits were started. He also stated that he was not present when KIMS were being started, but he was shown how the kit was started. He did not recall seeing a QR code on the manual register. PW3 Joyce Gaki, in evidence in chief, stated that she did not see any manual registers on polling day. When cross-examined by Mongela, she stated that during the IBC training, she was told that manual registers would be used only when necessary, like when identifying a voter. When she voted, however, she was identified by KIMS, and so there was no need to refer to the manual register. PW4, one of the petitioner's polling agents, stated that the voters who were not identified by KIMS kits were photographed and shown where to vote. He stated in cross-examination by Mr. Mongela that I saw KIMS being started. I saw the KIMS kit take a picture. I know it was a picture on voters' register. KIMS worked from 6 a.m. till closure. In re-examination, he stated that people who are not identified in KIMS were photographed holding an ID. RW1 stated that KIMS kits were started through scanning the QR codes on the physical registers in all the polling stations. He did not receive any reports of complete failure of KIMS kits being unable to identify a voter. That the physical register is used only when KIMS fails completely, and in such cases, use of the physical register must be authorized by IBC headquarters. In cross-examination by Mr. Gachagua, RW1 stated that the petitioner did not specify any station without a physical register. When cross-examined and referred to paragraph 39 of his affidavit, the witness said that the physical registers were deployed 100%. He stated in cross-examination by Mr. Njiro that KIMS cannot start without scanning the QR code on the physical register, that the register used was the same one used in the 2022 election. RW2 stated in evidence in chief that a physical register was deployed in each polling station. RW3, the PO at Gitiburi 2, stated that I had a printed register of voters which I scanned the QR code to start KIMS. I did not choose the register of voters since all voters were identified by KIMS kit. RW4, PO at Gitiburi number 1, stated in cross-examination by Mr. Gachagua that she did not choose the register of voters except to open the KIMS kit. RW8 was a PO for Muchonoke polling station. He stated that he had a physical register on polling day and that no voter was turned away. He stated that the register was sealed in a clear plastic paper and it remained that way all day. He did not know how many pages the register had. The top of the register indicated the number of the voters in it, but he did not open it to verify the number of voters in it. During scrutiny, when ballot boxes were opened, the DR noted that in each box there were voter registers wrapped inside a transparent sealed plastic bag. The physical register had on its face a QR code which was used to open the KIMS kit when scanned. Once the KIMS kit was opened through scanning, the kit gained access to the soft copy content of the physical register in the paper bag. Further, when doing the scrutiny, the DR unsealed the physical registers, scrutinized and placed them side by side with the 2022 register and confirmed that they were identical in that they contained the same voters' names. In conclusion, it is demonstrated by the evidence that there was a physical voters register available at every polling station, that they had QR codes on them to open the KIMS kit at the polling station. The voter register contained in the KIMS was a soft copy replica of the physical register which had the QR code. No evidence was availed that any voter was disenfranchised since the physical registers were present and were also replicated inside the KIMS kit. The prevailing jurisprudence on use of physical registers is the UDA case, which is that such a register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been made out. So that issue also fails. Issue number 3, whether there was unlawful third-party interference with voter registration data and failure by the first respondent to secure and protect the register of voters. There are 2 key complaints sought to be demonstrated by the petitioner's evidence concerning interference with the voter register. These were as follows. Evidence of unlawful interference concerning registration of Collins Monene in Mbeere North from Ruiru, and B, the alleged transfer of Cecily Mururi Njage from Mbeere North to Karatina whilst the register had been frozen. PW1 stated that Collins Monene did not appear in the 2022 register and that he was not a voter in Mbeere North. Collins Monene was not called to testify. In response, RW5, Edwin Ibrahim Golicha, IEBC's voter registration officer at Ruiru, stated in paragraphs 3, 4, and 5 of his affidavit, through an open KIMS kit, a registration official at IEBC can register a voter at any registration center within the Republic of Kenya. That on 8 October 2025, I registered Collins Muriuki Monene as a voter through use of an open KIMS kit at my Ruiru constituency office. That the said error occurred due to human error on my part and was not intended to favor any candidate during the conduct of the by-election. In his oral evidence, RW5 stated as follows. On 8 October 2025, I was overwhelmed by a large number of youthful voters. In the process, I made a mistake of registering Collins Monene. As soon as I realized the mistake, I reported to ICT, the ICT of IEBC. Monene had appeared before me that day. I realized he was registered. I don't know if he could have appeared on KIMS. Collins was the only one I registered. In cross-examination by Mr. Ndegwa, W5 stated as follows. What I did amounted to an alteration. All registers had been frozen as at 22nd June 2022. I was aware of this. It is an alteration. I had no authority to alter the register. I did inform ICT. I did not inform the Commission itself. Section 33, I think the reference was actually to Section 3, but on the record it shows Section 33 of the Elections Act was then read out. RW6 was Paul Wachanga Mugo, ICT officer at IEBC. He stated that he was informed of a discrepancy between the physical register and KIMS, that the former had 399 registered voters while the latter had 400. He asserted that the discrepancy was caused by inadvertent human error by a registration officer at Ruiru, resulting in one extra voter. In cross-examination, he stated that Collins Monene was registered as a voter on 8 October 2025 and that he was alerted by the Assistant Registration Officer RW5. Once he was told, he checked in the system and flagged out Collins Monene. That meant he highlighted Collins Monene as a new entry, since one cannot remove the name, but can only flag it out. In cross-examination by Mr. Njiri, he stated that even though the register was frozen, for purposes of the by-election, an open kit can register voters anywhere in the country. He did not audit the register to find any other unauthorized registrations. When cross-examined by Mr. Ndegwa, he admitted that such registration affected the character and integrity of voter registration. During scrutiny, the DR made the following findings regarding the issue of Collins Monene under paragraph 414 of the supplementary report dated 22nd April. I quote, according to the KIMS logs and total registered voters, according to the KIMS logs, the total registered voters is 400, whilst according to the 2022 register of voters, registered voters are 399, and according to the 2025 by-election register, the total voters registered is 399. The discrepancy was noted down in the polling station diary at page 30 by the PO. The same is also noted in the initial DR's report filed on 17th April 2026. It further quotes that number 154 on KIMS logs indicates the name Muriuki Collins Monene, yet on both the 2022 and 2025 registers, number 154 is Mutala Daniel Muema. Therefore, Muriuki Collins is not in the two register of voters. The petitioner was interested in knowing whether Muriuki Collins Munene voted in the by-election. The same was checked in the KIMS logs, voter register using the national ID number, and the result was Muriuki Collins Munene did not vote in the by-election. PW5 Cicely Mururi Njage stated that she had been a voter at Gikuyari polling station since the year 2022. She said she was unable to vote in the 2025 by-election as she could not be identified through KIMS. She was instead informed that she is a registered voter at Karatina. However, she asserted that she had never transferred her voting station. When she checked on the online IEBC portal in her phone, she found that she was indeed registered in Karatina. During scrutiny, the DR noted in paragraph 4 of the supplementary report as follows regarding the case of Cicely Njage. The petitioners asked to check out the status of one Alex and Cicely Mururi Njage. Both ID numbers are retained in the hard copy of the report to confirm of the DR's report to confirm whether they were in the register of voters 2022, KIMS register, and KIMS logs. The findings are as follows. Cicely was not present in both register of voters 2022 and 2025 for Gikuyari polling station and KIMS biometric register. Her national ID number appears at 0710 AM on KIMS logs under the citizen ID number so-and-so on 27th November 2025. Voter ID belonged to a polling station number so-and-so, which is Nyeri County, Mathira constituency. So she was not present in the voters register. With regard to Alex, which is not necessary in this case, he was not present in both the 2022 and 2025 register of voters. I'm only reading this because it's in the report and the petitioner had asked during scrutiny. Both never voted in Gikuyari polling station. From the evidence above, particularly the admissions of RW5 and RW6, the following conclusions are inevitably drawn. One, that an IEBC registration officer using an open KIMS kit can register a voter anywhere in the country for a constituency. Two, that an open KIMS kit can override the freezing of a register in an area scheduled for an election. It is also concluded on the issue at hand that there was no proof availed that the admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof, and thus no finding can be made, of the fact that the stated interference with the register affected the will of the people. Issue number 4, whether there was violence, intimidation, and disruption of voting in violation of the Constitution, the Electoral Code of Conduct, and electoral law. Incidents of violence were primarily shown through evidence to be significant at Kaungu polling station. PW1 testified that he was informed of incidences of violence, voter intimidation, and disruption of voting at various polling stations. He stated that at Kaungu, the Embu County Governor and the fourth respondent forced their way into the polling station and chaos erupted. That the aides accompanying state officers fired shots in the air. He was shown videos titled Violence Shooting Victim, which had been admitted in part, and CS Roko Voter Agitation Kanyuambora. These are 2 videos. PW1 was not present at Kaungu at the time. PW8 James Mureithi Njage, who stated that he voted at Kaungu polling station, he said thereafter he left the station and was standing outside the gate of the polling station waiting for his friend. While standing there, he was shot on his upper arm. He reported to the police that he had sustained a gunshot wound before going to Embu Level 5 Hospital, where he reported the nature of his injury. Dr. John Mwangi's medical report indicated that the witness reported that he had been shot. Produced in evidence, there are handwritten doctor's notes showing that he had reported a shot wound and that there was a slight crack in the distal end of his radius. RW7 Paulino Nthiga Njeru, the PO at Kaungu polling station, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. Voters were aggravated, so he stopped the election process for 30 minutes. When he reopened, the voting continued, but the voter turnout was lower than the earlier turnout. He recorded as follows in the polling station diary. Quote, "The locals and some politicians disrupted the polling process where some window glasses for the polling station were broken. Voting was disrupted between 13:45 hours and 14:15 hours. Action taken, the aperture was sealed at 13:45 hours. All election material and officials were put under tight security. The RO ensured there was backup security." In cross-examination by Mr. Njiri, he stated as follows concerning the incident of invasion into the polling station at paragraph 9. "I say there was a shooting incident. Shown page 345 of the PSD. He says, I recorded that there were politicians. I don't know which politicians. I do not know their names. The politicians and locals affected the polling by stoning the classroom. We had to stop the process of polling. The shooting was past noon. Yes, the number of voters reduced." PW6 was shown a video titled "Armed Goons, Gitiburi Unattended." It concerns the period after the fire at Gitiburi 2, and there are crowds with some of them armed with sticks. The video titled "Gitiburi Part Violence 001" also shows agitated people armed with sticks confronting the IEBC officers after the fire had occurred at Gitiburi polling station. On viewing the videos, the court notes as follows that the most significant violence was experienced at Kaungu polling station. The video showed vehicles like Prados and Land Cruisers without number plates driving out of the polling station with hordes of people armed with sticks, jeering angrily and demanding their removal. At Kaungu, there is evidence of PW8 who testified that he was shot outside the polling station. There is no doubt that whilst Kaungu was the epicenter of the violence demonstrated in this case, there are instances of disruption and commotion wherever any unusual event occurred, such as a fire or attendance of politicians at polling stations in unmarked vehicles. As to whether this violence has a substantial effect on the outcome of the election, the findings from the supplementary report dated 22nd April 2026 indicated that at Kaungu, from the opening of the polling station at 6 a.m. up to 1 p.m., the voter turnout was 347 voters. From 1 p.m. up to close of polling at 5 p.m., not forgetting that the violence occurred at around lunch break at around 1:30, the voter turnout declined to 49 voters. This is clearly shown in the highlighted row in number 2 on table 3, which I have extracted and put in the judgment. The extract on row number 2 of the table 2 shows as follows. Record of voter turnout at the polling station. Details as per the PSD. Total registered voters were 641. Voters who had voted at 900 hours, 177. At 1000 hours, it should be 11 actually, because it goes by every 2 hours. It records every 2 hours. At 1100 hours, 287. At 1300 hours, 347. So between morning and 1300 hours, the voters were 347. From 1300 hours to 1700 hours, the total voters were 396, which shows that merely 49 people voted in the afternoon. The other witnesses to violence, as to violence, was witness to violence was PW6, Dan Degwa Macharia, the agent for Safina Party at Gitiburi 2. He said that he traveled from Laikipia to participate as a party agent. He testified that after the fire started, the station was invaded by about 300 outsiders, some armed with sticks, accompanying CS Roko. He stated that the group entered the classroom and took things outside the classroom. He protested against CS Roko commandeering the station, but was handcuffed by police officers who were not uniformed. He was then beaten and detained in a police vehicle until 8 p.m. on that day. He said that he was personally beaten by CS Roko and was later sent away from the station, denying him a chance to witness the vote counting exercise. In cross-examination, he confirmed that the video did not show the ballot boxes being carried, that he saw ballot box aperture being sealed, that he later saw the ballot box being removed from the matatu vehicle by the presiding officer and his assistant, that he could not tell if seals were broken, and that the ballot boxes were taken to Stream 1. He did not report this incident to the police. Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu stations, or was systematic or pervasive within the electoral area or constituency. I'm talking about the evidence. I'm not talking about the allegations. It's the evidence. That is where the weakness of your case was. It's the evidence. The court relies entirely on what is brought into court. So if there are 500 other people, and I know the people of Embu may be feeling something about this, there may have been 500 other people who faced violence. It is possible. But unless the evidence comes into the courtroom and those people testify, proof is not there. The court goes by what is provided as evidence. I was where? Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu. In fact, in Gitiburi, the only evidence that was provided of violence was Ndegwa, Dan Ndegwa, who said he was beaten by the CS. Then, of course, there was the incidents of the commotion and people with sticks, but that was not indicated as violence. I am not persuaded in the circumstances that the violence substantially affected the overall result of the elections. Despite this, though, there is no doubt that after the violence occurred at Kaungu, there was a decline in voter turnout from about 347 voters between 6 a.m. and 1 p.m. to 49 voters between 1 p.m. and 6 p.m. The voter turnout at Kaungu being 53.9%, compared, for example, to Gitiburi, where there was a turnout of 66.5%, and compared to Gitiburi 2, which had a turnout of 61.8%. This is compared to the average constituency voter turnout of 61.92%. So Kaungu achieved 53 instead of the average 61. If we do a calculation, theoretically, we can say Kaungu may be said to have suffered a turnout decrease of about 8%, or 51 votes or voters, as against the constituency average. So on that issue, again, the petitioner fails. Issue number 6, whether there was bribery, treating and undue influence in violation of the Election Offences Act and the Constitution. PW1 stated that he received reports about serious cases of bribery at Kune, Kageri, Itira, and Kianamu polling stations. He also alleged that bribery was connected to the high numbers of assisted voters. However, he was not able to give any concrete direct evidence of bribery. PW2, the petitioner's chief agent, received reports of bribery at Triandu polling station and treating of voters with unga and cooking oil at Makunguru polling station. He highlighted a person called Ndawa area who was allegedly involved in bribery, but he had no proof that the named person was acting on behalf of the fourth respondent. PW3 testified that she witnessed bribery at Kanywambora polling station, but gave no further details. PW10, Anseta Wakere Maringa, and PW11, Lydia Mbuya Njeru, were the key witnesses for the petitioner on the issue of bribery. PW10 testified that on the occasion, on the election day, she was called by her former MP, Murioki Njagagwa, who she knew. He asked her to go to the home of her neighbor, Edward Njage. And when she got there, she found many people and was informed that there were presents available for them. She saw those items in Edward Njage's home where Njagagwa was. They were then each given 2 kgs of maize flour, wheat flour, and rice, and Kenya shillings 500. The items were to be in exchange for her votes for the UDA government candidate in the by-election. When she refused to take the items and the money, she was told that she would not benefit, and Njagagwa left the items for them. Shown her affidavit, she said there was no indication that she took any bribe, though she alleged that she saw others taking bribes. In her oral testimony in cross-examination by Mr. Gachagua, PW10 stated as follows: Njagagwa was bribing people. He did it on behalf of Wamudende. He told us so. I did not see Wamudende. I took 2 kgs of rice, 2 kgs of ugali, 500 shillings, and unga ya chapati. I ate them. It was not written that they were for the election. I was hungry, so I ate. Others also got and they ate. Many who couldn't write also ate, and they were helped to vote. I have no affidavits of others involved. Lydia was with me at Edward's house. We were given the gifts together. Cross-examined by Mr. Kamoto, she reiterated, I think this is when Mr. Kamoto spoke the local lingua. You forgot you were in court. Cross-examined by Mr. Kamoto, she reiterated that she indeed took the gifts, that initially she declined, but eventually she took the things since they belonged to the government. PW11, that was, I think, Lydia Mbuya, testified that she was invited to Edward Njage's home where they were offered bribes in the form of food. They were offered the goodies so as to be assisted to vote for the fourth respondent, and that she agreed to vote for the fourth respondent. That is in paragraph 4 of her affidavit. They were told that if any of the invited recipients refused to vote for the fourth respondent, they would not benefit from the gifts. That most people took money and they were swayed to pose as voters needing assistance. In her oral testimony, she said that she was given 2 kgs of sugar, 2 kgs unga, 2 kgs ungangano, and 500 shillings by Njagagwa, who told them to vote for the fourth respondent. Further, PW11 testified that there were 2 ladies and 1 man who were given Kenya shillings 15,000 to find people who would vote for the fourth respondent, and that some of them would pose as assisted voters. She considered that she took the bribes and was influenced to vote as suggested. In cross-examination, she stated that she witnessed bribery outside the gate of the polling station, but she did not report the vice generally. She reasserted that she was bribed and the bribe was intended to influence her vote for the fourth respondent. In the present case, PW10 and PW11 have admitted repeatedly that they took the bribes intended to influence them to vote for the government candidate, namely the fourth respondent. I listened carefully to their evidence in which they corroborated one another. They did not strike me as incredible, lying, or flippant. I believe their testimony as to the fact that they took bribes. I do not doubt that they were at Njage's house, where they said they were when Njagagwa offered them the bribes. The submission by the petitioner was that the bribery was not only intended to influence the voters to vote for the government candidate, but also enable them pose as illiterate voters needing assistance. However, neither PW10 nor PW11 alleged that they were actually assisted to vote, nor was a single witness brought to testify who was an assisted voter. On this, the IEBC submitted that whilst PW10 knew that she was committing an election offence by taking the bribe from Gachagua, she did not report the same. IEBC, I challenge anybody to ever report to you that they were bribed, or any briber to report to you that they gave a bribe. There was no witness availed by the respondents to controvert the evidence of PW10 and PW11, although Gachagua was named in the affidavits, as was Njage. The petitioner invited the court to find that the bribery, treating, and undue influence were offences in violation of the Election Offences Act. However, this court's jurisdiction is to hear petitions under Article 105, which provides as follows. The High Court shall hear and determine any question whether A person has been validly elected as a member of parliament, or B, the seat of a member has become vacant. Clearly, the constitutional jurisdiction of the election court is limited to making a finding on validity of the election and vacancy of a seat. The court does not sit as a criminal court when conducting an election petition. Thus, the finding this court can make regarding bribery, treating, and undue influence is that prescribed under the Elections Act and no other. In that light, the provision of Section 87(1) of the Elections Act enables the election court to make a determination regarding an electoral malpractice of a criminal nature. The provision, that is Section 87(1), is in the following terms. An election court may, at the conclusion of the hearing of a petition, in addition to any other orders, make a determination on whether an electoral malpractice of a criminal nature may have occurred. This provision merely entitles this court to make a finding as to whether a malpractice of a criminal nature may have occurred, not that it did occur. Further, in an election petition, the election court has no jurisdiction to determine a criminal matter or whether an offence under the Election Offences Act was or has in fact been committed, since that is an issue squarely within the jurisdiction of a special magistrate's court. Such court must be specially constituted by the Chief Justice under Section 23(1) of the Election Offences Act, which provides as follows. The Chief Justice may, by notification in the Gazette, appoint as many special magistrates as may be necessary to hear and determine matters relating to offences under this Act. In light of the foregoing, this court as an election court can make a determination only on whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Elections Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. Ultimately, however, the question I must answer on this issue is whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election. From the evidence above, I am unable to find that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. We are talking about two witnesses who said they were bribed. And I only accept their evidence because it was not controverted by the respondents. Issue number 6. Whether there was a broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling. The petitioner made claims of a wide range under this issue, alleging broken chain of custody and unlawful handling of election materials. However, he was not an eyewitness in any of these events, neither was his chief agent, that is PW2. The main evidence that emerged in respect of this issue was that concerning Mbeere Primary School Polling Station 2, where there was a fire, and Kaungu Polling Station, where there was an invasion by unauthorized people. PW6 Dan Degwa, the party agent for Safina Party, stated that he was at Mbeere 2 when a lamp fell and triggered a fire in the classroom that was set up as a polling station. He said that they rushed out and then he rushed back into the room to retrieve his phone, which was charging there as he helped put out the fire. He stated that CS Roko came to the station with about 300 people in tow, and they occupied the classroom, were placed inside the Nissan van, which was left unguarded outside, and he believed that they could have been interfered with. He said that by that time he had been handcuffed on the instructions of CS Roko, and some agents had run away. In his affidavit, PW6 could not confirm what happened at the voting in the classroom, as he was seated at the back observing. In his oral evidence, he reconfirmed that it was about 5 p.m. when the fire broke out, as the PO was attempting to light a gas lamp. That bedlam then broke loose, and the crowd of people started coming into the polling station. A video named NNK23 Collection Gitiburi was shown. He said that the crowd comprised of about 300 people, and at the time the ballot boxes were still in the classroom where they were left when the fire broke out. He further stated that locals salvaged the ballot boxes and took them to the vehicle, that the PO and DPO were not in the vehicle when the ballot boxes were taken to it. IEBC officers were called to come and collect the boxes from the vehicle, and they complied and picked the boxes. On further cross-examination, PW6 stated that there were things taken outside the polling station classroom by strangers. He said that he did not see in the video the ballot boxes being carried out by locals to the vehicle. Upon viewing the aforesaid videos, the court noted that as follows: there indeed was a fire, that there was commotion at Gitiburi, that there was involvement of large crowds of people, some armed with sticks, that there was also a van into which some IEBC officials in IEBC reflective vests were seen attempting to enter. However, no ballot boxes were seen in the videos. Hence, the videos do not support the allegation of third parties handling, I'm talking about handling, the ballot boxes. In his affidavit, PW7, Simon Kariuki, a voter at Gitiburi, stated that shortly after the fire was controlled, CS Roko came to the station accompanied by people armed with sticks and rungus, and they took the ballot box to the vehicle whilst beating people. That CS Roko demanded that the ballot boxes be brought to one classroom and ordered that the ballots from both Gitiburi 1 and 2 polling stations be counted together. One of the ballot boxes emerged from amidst the crowd and was given to CS Roko, who gave it to IEBC officials. That CS Roko demanded that the votes, that the votes be counted and tallied. He did not witness reopening of the ballot boxes again, and he denied signing forms 35A. He stated that the counting took place in one polling station at Gitiburi. RW4 Jane Karim Induma was a presiding officer at Gitiburi 1. It was her evidence through her affidavit that after the polling ended at 5 p.m., she secured the room before counting started. She confirmed that CS Roko came to the station and caused commotion. She noted that there was a fire at Gitiburi 2, that she prepared the polling station as a counting room. She made no mention of Gitiburi 2 in her affidavit. In her oral evidence, RW4 testified that there was a fire at Gitiburi 2. It led to a commotion because there was a large crowd of people. She took the ballot box and took cover in a vehicle. That vote counting started at 7 p.m., that the votes for Gitiburi 2 were also counted at Gitiburi 1. In cross-examination, she stated that she did not see CS Roko and that he was not involved. She admitted that she hosted another polling station and that no one authorized her to do so. When shown a video of the fire incident at Gitiburi, RW4 confirmed the incident was as depicted in the video. She saw the PO of Gitiburi 2 in the video with people in the crowd holding sticks at the scene. By that time, she said she had secured the ballot box in the vehicle. She said no polling officer for Gitiburi 2 was in the vehicle, but the boxes for Gitibori 2 were there. On re-examination, her evidence was that after getting to the vehicle with her ballot box and with the security officer, she realized that she had left some personal items in the polling station. She thus left the ballot box in the vehicle to get those items. That was the only time she left the ballot box unattended. RW3 Lydia Kamau was the PO for Gitibori 2. In her affidavit, she stated that after closing the station, she closed the KIMS and sealed the aperture at 5 p.m. She then called for a short break before counting began. At around 5:30, her deputy, Felix Mwaniki, lit a gas lamp which burst into flames. She managed to secure the ballot boxes. She telephoned Siakago police station and reported the incident and was issued with an OB number such and such. She stated that CS Roko came to the station and that his arrival caused some commotion. RW3 further stated in her affidavit that during the brief incident of the gas lamp explosion, the election materials remained secure. Let me read that again. RW3 stated that when the fire broke out, she took the boxes to the vehicle hired by IEBC together with the security officers and agents. She said that she and her team transferred their materials to Gitibori 1 to count ballots, and they found Station 1 already going ahead with counting. In further cross-examination by Mr. Ndegwa, she stated that the forms which were burnt were KIMS Forms 32A. From the DR scrutiny report of 17th April 2026, the DR noted that the PSD for Gitibori 1 recorded the fire incident as follows. Incidents recorded on page 30 as an accidental fire in Station 2 at 17:30 hours. Fire was put out and calm restored. Security backup. In Gitibori 2, the PSD indicated that the PO recorded gas cylinder exploded and some of